I think it'd be fair to say this was a court ruling here that had a lot of people sit back and try to understand why our highest court in this province decided on it. It is the case brought to it which involved sexual abuse or sexual abuse material, and basically a case that they've had, I guess, since 2018, someone who had pleaded guilty on one count of possessing, accessing, and distributing material like that. The court ruled it was unconstitutional for him to receive a 12-month sentence. Pearl Eliadis is a human rights lawyer and associate professor at McGill University, and she is on the line. Pearl, thank you for coming on. As I said, I think when people saw this, they thought, well, this would be a slam dunk. This guy will go away, but the court ruled otherwise. What was the rationale here from what you understand?
The case involved somebody, if we're talking about the same case, Klang versus the Queen, the case involved somebody who had a mental age of somewhere between 8 and 11 years old, and it involved somebody who also suffered from various forms of mental illness and had been ruled in separate proceedings incapable of taking care of their own affairs. So I think the important thing here, leaving aside the specifics of the individual, are that judges really have expertise and are in the business of looking at whether there's a fit between what happens. Is it a one-off? Does the person have a record? Is it something they did just once or over a prolonged period of time? And judges look at those things and make decisions about how long people need to spend in prison. So the takeaways from this, I think, Aaron, are understanding the individual circumstances of the case. Right. And, if you think about yourself or anybody you would want a court to take into consideration context, who these people are, whether they're capable of making decisions in a way that would treat them as adults who are fully responsible for their actions.
I guess from what I read, at least in the article that I had seen, the reference from the provincial court here was to a federal court, right? The Supreme Court here, which has dealt with cases like these in the past. That's now going to be the reference going forward? That's always going to be what happens?
So there's a long history of courts looking at mandatory minimum sentences. The latest one that the courts, I think you're referring to, is the Supreme Court of Canada's decision called in 2025. And that was a court, that court decision, which is binding on the rest of the country, also looked at cases involving what most of us would call child pornography, two of the main three areas of that case. So the three being accessing pornography, possession, and distributing, right? With distributing being the most important one, or the most serious one. And so what the courts do in these situations is say, is the sentence fair? Is it proportionate? If you look at what the person's actually done and the sentence that's being imposed on them, does it even make sense? So you're not only looking at the severity of the offense, but you're looking at who the perpetrator is. And when the perpetrator is somebody who is, has a mental age far below their actual age, who have developmental disabilities, mental illness, even if they're capable of discerning right from wrong, right? You think about an 8-year-old kid, most of them know what's right and what's wrong, right? But you wouldn't hold them to the same standard, for example, you would an adult. And that's kind of what was going on here.
So I guess that means going forward, if we put these cases, because there have been others, and I imagine there will be others, they will each, I guess, be judged not just on their own merit, but on, as you said, I guess the mental ability of that person, because that's really the only thing here that sticks out to me, right, is the fact, as you said, we know this person, based on the evidence presented, had a mental age, and therefore that was taken into account by the judge. Is that where it ends?
No. So individual circumstances aren't just about mental ability, right? It could be the fact that somebody did something really dumb. They have no priors. It was a single case. You want to put that kind of case at the lower end, right, of your sentencing. So it isn't just the person's mental ability. And again, I think the point being made here is, mandatory minimum sentences, not all of them, and the courts have been very clear to say some of them might, be fine, but there have been real constitutional problems with them because they do not allow the court to look at your circumstances as an offender, or my circumstances as an offender, and say, what, we think this person should be at the top scale or this person should be at the bottom scale. And judges are uniquely positioned to make those assumptions. So you look at things like, as I said, has the person done anything like this before? Do they have priors? How old are they? Do they have mental illness? Don't we all as a society want people to be considered for what's going on with them? The circumstances of sentencing are an age-old part of what judges do.
I wonder for people who look at this case and don't necessarily understand the details the way you're explaining, whether they don't think that at least mandatory minimums kind of send a message to people, right? That this is what you're in store for if you get caught, and that by then going back and changing, the rules of the game, if you will, it's a different message that goes out.
Yeah, so, I agree, Aaron, that there is a tendency, when something like this happens, people often react understandably, without knowing the circumstances of the case. But part of the reason I hope you do these shows and people like me talk about them is because the details do matter. And when you are caught, when anybody is caught, in the jaws of a justice system that can be pretty terrifying, you want to make sure that it's agile and subtle enough to take into account what you're doing. And I would also say, in terms of that very important thing you just said, the message that's being sent to the public. Surely the message being sent to the public is, we're going to take into consideration who you are, what's been going on with you, whether you're capable of telling right from wrong. This individual, as I said, as an adult, had the mentality of someone between 8 and 11 years old, already judged and capable of taking, so surely the message there should be a different one. And surely we don't want a one-size-fits-all justice system, right? We want one that treats us as individuals.
Agreed. Pearl, I always appreciate your insight. I thank you so much for the time.
Thanks so much for having me on, Aaron.
Take care. Pearl Eliadis, human rights lawyer, associate professor at McGill University.
The newest tracks. Let's go. New music. And the next big thing.
Always on the new music first.
Your first place to hear it all.
'Cause you gon' like it, love it, wanna play it twice. Playing now.
iHeart New Music. Your digital station for brand new drops, fresh finds, and tomorrow's bangers.
I think we need something new.
Discover iHeart New Music. Always fresh, always first. Stream now on the free iHeartRadio app.